Okay, so these are the notes and the key understanding that I want you guys to get to. Your assessment task, if we start with where we want to end up with, your assessment task is going to be a case study where you're going to have to consider whether some people were negligent or not. You're going to have to come to a judgment around whether someone was negligent, whether people were negligent or not.
Is that for the thing?
That is for your final exam. That will be the exam block exam.
Wait, so is it, can you say that again, please?
Your final assessment task in exam block exam is going to be a discussion of, you're going to be given the facts of a situation. You're going to have to decide whether there was negligence involved or not. So this is the basics. You're going to have to put things against what needs to exist for negligence.
You don't have to say what they could have done to not.
No. Different focus this time. This is, you're a legal person. You're looking at a situation. Are they negligent? What's your advice? Is this action that's happened negligent or not? And justify, explain why, and then talk about what the consequences of that might be.
How big are you expecting your response to be?
It'll be on A4 paper, so just A4 size will be the size response. In terms of the number of words, it'll be, I think, 600 to 800 for the older students and 4 to 6 for year 11s.
Oh, so it's not big.
It's not a huge one. It's not a huge one.
So you're going to run out of stuff to write.
Yes, I am going to let you use computers again. I thought that worked very well. You're not required to use computers. It is an option that I will give you. The only thing I'm a little bit uncertain of, it took us a while to get the login. So for those people who were in 3 classes of mine, which was Josie, they saw the first one, it didn't work very well, through to it working exceptionally well by the third one. And because we've lost Mr. Kleinschmidt, it may just be a bit rough. But I will do all those things that I did last time, in that I'll let you just use your own login if you have to go to that. I'll let you use a USB stick. All those sort of things to make sure that that's not a source of stress in the exam situation. But yes, you will be able to use your computers if you choose to in the exam situation. Okay, we've already talked about the 3 elements that need to be in place to prove negligence, and they're about to magically come up on the board. Right, the first of these is, does a duty of care exist? Does a duty of care exist? Is there a relationship that means there should be a duty of care? We'll talk about these in more detail. The second thing, and I would be taking these down as notes, is saying, has that duty of care been breached, and is there proof of this? Right, we said, okay, first thing we've got to establish, does someone owe someone else a duty of care? And then we get to this point, has the duty of care been breached? And proof of that. Right? And has damage been caused by the breach of the duty of care? Josie was just talking some science outside the photograph, talking about how fast people would fall if they came out of a plane. But you might look at this from a legal perspective and say, okay, if I'm going and I pay money to go skydiving, does the skydiving company have a duty of care to me? And you say, yeah, they probably do. I was down in Melbourne, actually, St Kilda Beach, and I saw a bunch of people skydiving down from there. It was very interesting to watch. So you say, yes, they do have a duty of care. Now, is there a breach of that duty of care? Well, what might happen if the equipment isn't properly organised, for example? And then you'd look at what damage gets caused. So maybe the first parachute hasn't been properly packed. You have to land with the second parachute. The second parachute means you land a lot faster than you would need to, and you break a leg as you're coming in to land. You'd say, okay, you look at those things. Does a duty of care exist? Yes, if I'm paying money to go skydiving, it probably does. Has it been breached? Yeah. If it was something they did that meant that the first parachute didn't work, yeah, that might be it. And has damage been caused? Yeah, you've broken a leg. And there are a whole lot of follow-on things from that. Josie.
What if it's not their fault the parachute opens? Can you still sue for it?
Yeah, there may be other things there are some different defences that happen with this, and you'll see that there are some issues that come into this. First of all, we have to recognise there is a recognition that skydiving is a risky activity, and so there's some responsibility that goes there. And there might be a case of someone else having some responsibility, someone else who hasn't done the right thing there, maybe the manufacturer of the parachute. So in my example, I was assuming that the person had done something that meant the parachute didn't open. Okay. Just have a last look for that. We've looked at this case Donahue versus Stevenson, 1932. It's probably the most famous negligence case. And it takes this idea that we all owe each other a duty of care into a legal situation. This is the slug in the bottle case. Two friends went to a cafe. One of those friends got sick after drinking a bottle of ginger beer that had a decomposing slug in the bottle. And the question was, did the person who manufactured that drink, who was involved in that drink, did they have a duty of care to the person who was drinking it?
Yeah, but it's like 1932. I'm
19
like, get mad about it.
It was a long time ago. This is one of the first ones. And the judge says you must take reasonable care to avoid acts and omissions. Omissions means things that you don't do. So it's not just things you do, it's things that you may not do. For example, the parachute incident. If you hadn't properly checked that parachute before the jump, that may be one of the things that comes back. So it's things you do, things that you don't do, that you can reasonably foresee would be likely to injure your neighbour.
But is it your responsibility to check your own parachute?
It would depend on the situation. So if you were very experienced as a skydiver, absolutely, that might say it's your job. However, if you were just paying them first time you've jumped out of a plane, you've paid them $200 to do your jump, then you don't have any skills, you don't have any ability to do that. And we'll look at that breaking down. So that's the first thing, this idea of a duty of care. And that's going to be the first thing you have to look at when you look at a case and say, is there a duty of care owed? We talked about someone who was suing Coles for a bunch of money for slipping on a grape. So the first question is, was a duty of care owed to that person? The answer is yes, there is a duty of care. Now, it doesn't mean that you're going to satisfy all three criteria. So let's have a think about that. But a shopping centre does owe a duty of care to its customers, and we've heard Lara talking about the things that they do to make sure it's a safe environment.
Just because there's grapes on the floor doesn't mean, like, I see customers all the time who get a bag of grapes and eat grapes as they're going. The grapes fall out of their own bag.
Yeah.
So
I do that.
it's not, and it's like a guy who dropped a carton of eggs once and then was about to walk off and leave eggs on the floor.
Yeah.
The only reason I told him was because I was about to walk around the corner. He was going to walk away and leave it.
Yep. So we haven't got to the details of what's happened, but we're saying with the grape on the floor, yeah, the supermarket does owe them a duty of care. Now that doesn't mean that that doesn't prove everything. Remember, there's more parts to this. So let's have a look at this. When we go into more detail, so we've got those three big things. Duty of care, has there been a breach, is there damages? Here are three tests around duty of care. So are the consequences of harm or damage reasonably foreseeable? Is there a closeness between the parties, and is it fair, just and reasonable that the law imposes a duty? And this is one of the ones with the grape on the floor of Coles. You might say Coles would argue that they're careful with their floors, and so they can't be responsible every time a grape is lying on the floor. People have to take responsibility for their own grape avoidance strategies. Right, so that will be one that would challenge that. So there's three things there with duty of care. Are the consequences of harm, damage reasonably foreseeable? We think about the not properly packed parachute. Are the consequences of harm, damage reasonably foreseeable? Yeah, they are. Is there a closeness between the two parties? Yeah, if I've paid my money to dive, absolutely. Is it fair, just and reasonable that the law imposes a duty? In this case, for the parachute, you'd say yes. For the grape on the floor at Coles, you might say no. Maybe it's not reasonable, provided they're doing a whole lot of things, they're being careful. And you see once they've mopped the floors, they put the wet floor sign out, and on wet days they do that as well. They could go through a whole lot of precautions they're taking that are reasonable that they take, but being aware of every single grape that falls on the floor may not be.
For our assessment, I'm assuming that we would answer all of these questions to prove whether there is negligence involved.
To an extent, if you're disproving it, you might just narrow in on some that say this disproves it. Your C-level answer is going to just deal with the three questions: duty of care owed, breach, and damages. When you get to your Bs, you're going to start to look at these smaller elements and say yes or no. And A's, you're going to start to bring in other cases and maybe some reading of the legislation.
So if we're going to be answering something like is it fair, just and reasonable?
Yep.
Like, I would assume that you'd want reasoning why we think it is or it isn't. So what would be an example of how we would what we're saying isn't just making it up.
In this case, fair, just and reasonable.
Yeah.
You'd be looking at whether it's like sustainable or not. So, for example, in the Coles case and the grape on the floor, you might argue, well, if that could happen coincidentally. There might be some stuff in the stimulus material which happens in this case. Coles said they weren't even aware of it. And you might say, well, this becomes very, very hard. This becomes too heavy a burden for Coles to do. And you might contrast it with, for example, when they mop their floors, that they have to put a sign out and let people know. So you can say, well, that would be reasonable to impose a duty. But if every time something like that happened, you might say that is an unreasonable burden, because it's going to lead to a whole other lot of cases. An opening of the floodgates is what they talk about. So that's element one. That's our duty of care there. Okay, those three aspects.
Oh, so
Yeah.
when you actually write down the answer about the duty of care, is there any way you can go further from that?
Cases would be the next step.
Yeah.
Cases or referring a little bit to the legislation. We'll have a look at that to see how we can. Yeah. And also then being aware of the criteria. Okay. So this will fit the criteria your criteria quite nicely, because you work on the three different criteria. You're going to be able to show some knowledge. Think about just trying to foreground it in a little bit. Here you're probably going to show knowledge of court processes. That's going to be the bit that we're probably not going to talk as much about in class. You might talk about civil matters in front of a judge generally. You might talk about common law, how important case law is, and give some examples. That's where your knowledge is going to come from. Then you're going to think about these elements and compare it to the case, and then you're going to have to come up with what your decision is. So your recommendation, the third criteria, is going to be your decision in this case, and why. Okay, element two. That there's a brief breach of that duty of care and proof. And here we come down to this important element of the ordinary person. Because it's the ordinary person who makes that judgment. Who the ordinary person
So
is?
somebody not involved in the case, somebody outside of it, or
The ordinary person is a concept, and the concept is that what would the average person think is reasonable?
so it's not an actual.
It's not an actual person, yeah. We won't be getting in ordinary person for a guest lecture.
Well, I thought it was. I was like, how do you determine?
No,
who's
it's the
ordinary?
judgment of the ordinary person.
Oh,
It's
that's
what
what
you,
you-
me, as an average sort of person would think.
Okay.
And that's thinking about what that duty of care is. So go to that Coles case is, would an ordinary person think that it's reasonable that Coles is checking every 5 minutes as to whether or not there's any grapes that have fallen on the floor?
I just don't understand why an ordinary person can't just pick up a grape when they know they've spilled something, when they know there's not one on the floor.
But what if you don't know you don't want the floor?
Yeah.
I've seen people watch grapes fall out.
So some people behave in a way that's not
and
ordinary,
drop
and that
eggs all over the floor.
that imposes a challenge. I wonder,
Like, people are just
I wonder,
dumb.
Lara, if someone dropped eggs on the floor and chose to walk away with that,
He did.
is that, so you've given that example, is that an element of negligence, right? So did they owe a duty of care to the other shoppers in the store?
Yes.
I would say, yeah, there's proximity there. Is there damage that's foreseeable? Yeah, if you slip on egg goo, you can fall over. Would a reasonable person say that by walking away from a fairly significant mess you've made, I think you could make an argument that a reasonable person would think that, no, they should go and get help to clean up their mess. And indeed, from what you guys have said, that looks like a reasonable suggestion. Okay, some of the factors the court considers. The degree of risk, okay, and one of the other issues with the grape is you might say a grape on the floor is not a hugely high-risk situation. It's not ideal, but it's different to a parachute that doesn't open. What precautions can you take? How practical is it to check the floors for grapes every 5 minutes or whatever? And given that Coles will have some sort of systems in place to make sure that they are checking regularly, how much harm is likely to come from it? Generally, you wouldn't expect people to fall over from stepping on a grape, although you could see how the juices and that could make that happen. And the social importance of the risky activity, well, that doesn't fit into this situation, but it might be more, for example, a camp that people take on. there may be an argument that it's reasonable to take a little bit more risk on a socially important activity around that, or playing sport, something like that. So there's the second element, breach of that duty of care. And proof. You need to have reasonable proof of that. And I think in this case, this is where the grape on the floor becomes problematic, whereas you still run through with the parachute example and you still say, well, you should realise it's high risk. It's fairly easy to take precautions when you're checking how that it's packed. The seriousness of the harm where you're jumping out of a plane from 10,000 feet, and there's no real social importance on that activity. It's not something you should be done as a priority for social reasons. So really, in the case of a parachute that hasn't been properly packed and doesn't open, there would seem to be a clear breach of that duty. So have another last look if you are still writing. And let's get this third element, and this is the shortest one. Damages are caused by the breach of duty. So there has to be some damages that are caused. And I talked to you about the McCracken case, the case that I find very interesting, the footballer. He was injured. I think it was an injury to his back, playing first grade rugby league down in Sydney. It was found that the club owed him a duty of care. It was found that the duty of care was breached. However, the court also found that he made significantly more money out of his property development activities up around Airlie Breach than he would have as a professional football player, and therefore there were no damages caused.
Did the club have to pay his legal fees, or did he have to pay them?
I don't know. That would be a very interesting question, because that would have been a hearing and they would have looked at that. But I don't know what the judgment on costs was in that situation. Very interesting question. So two things. Of course, you've got to be reasonably certain. You've got to be reasonably certain that one thing caused the other. So sometimes, for example, food poisoning cases. There was a situation at the last Melbourne Cup where tragically someone passed away from food poisoning, an older lady, from a mayonnaise, because mayonnaise, as I understand, is made from raw egg. Is that right?
Yeah.
Yep, so it's made from raw egg, and so that's a problematic thing. There was some salmonella in the raw egg, and it wasn't until they were able to track that back and they were able to do testing in the actual kitchen, and they found that this is definitely where it came from. Whereas food poisoning at other times could be very hard to decide, has there been negligence? Where exactly did the food come from? Because there might be 2 or 3 things that you've eaten in the period where you could get food poisoning from leading up to that. But so you've got to be reasonably certain that one causes the other. And the damage cannot be too remote from the negligent act. That's about linkage. You can't just have one thing that happens and not the other. In the case of the grape on the floor at Coles, as I read the article, there was no immediate complaint from the lady. They didn't find about it until some time later. There was a doctor's report that happened a few days later. So there has to be a question. Are we sure that this actually happened in the Coles store? Coles have no record of it happening on that day. There's nothing that was seen. This is going to be another challenge for her to prove in the grape situation. However, the skydiving situation, the poorly packed parachute, well, then clearly there is a link between the two. Right? There's no other way that person got that broken leg except by falling more quickly than they should have. That's it. Are there any questions about that at this stage? Do we get the rough idea of what we're trying to do here?